I want to transition here rather to the next subject, which is basically settling cases or resolving cases and the differences and similarities. And I think a good way to introduce this topic is to borrow from the last one about the pretrial process, which is in civil, you have to mediate your case to get to trial, at least in our jurisdictions. You're not going to get to try a case unless you've mediated it. And for those that don't know, that's like a forced settlement conference with a neutral mediator, typically a former trial lawyer or judge who hears both sides and all that. But maybe you can talk about that process a little bit.
Sure. Well, don't forget, and something that we use is we actually move to dispense with mediation a lot. That's what we do. So yes, it is required, but there is a motion you can file to not do mediation and just say, look, and we, depending on, some judges are receptive and say, look, you guys don't want to mediate, I'm not going to make you mediate. I'm like, it's going to be a waste of time. This is a trial case. We're both big boys on each side of there. If you want us to make an offer, we can make an offer. Demand. I don't need
women.
Big women. I'm sorry.
Kidding.
Big people on the other side. We're all adults, right? We're all adults, and we can make decisions on each side. And so, what I try to do is look, and obviously these are discussions for different days. But when you're dealing with insurance companies, you want to, in order to maximize recovery for your clients, you kind of want to open the policy. What that basic premise is, you got to give the insurance company, depending on the case and if it promotes itself, an opportunity to pay the policy limits, right? And we do this sometimes, even if it's 10K, 25K, 50K, 100K, $1 million policy, afford them, this is our, and sometimes we do, this is our final unequivocal settlement opportunity for the policy limits. Make sure you send it to your client, or they are insured. The insured's privately retained lawyers, which I know you've recommended that they get. All of those things, because trial is not just is not an easy process for the plaintiff. It's not an easy process for some of these defendants that are just glorified figureheads, right? So you want to put some of that kind of that language in there about that. And we tried a case recently. We won again on paper, not what we wanted. We got a new trial on appeal, and the defendant, who I actually connected with on a personal level at a deposition, was like, I have to go through another trial? And we afforded the insurance company, like, look, just tender the limits. And
there's a real defendant, even if they're a figurehead, versus prosecutors who say, we represent all the people of the state of Florida collectively. Right. It's amorphous. Keila, let me ask you a question. I mean, civil, I don't know how you feel about it. Even all these years in, I feel like it's hand-holding. Judges tell me, no, go play nice with the other side. I mean, I felt like when I was doing criminal defense, there was always an ongoing dialogue when you wanted there to be. And the other side had a vested interest in keeping that dialogue going to clear a case for them. So what do you think the differences are between settling cases and criminal versus civil?
The differences, I would say one difference that comes to mind is the creativity that you can have a little bit in criminal. Again, we're talking about someone's liberty. So it is different when you have that conversation with the government. They have something that they already, whether it's their office that has these blanket kind of plea offers for this kind of crime, not really specific to the individual. It's kind of a little easier to at least have that dialogue and think outside the box of what that plea offer would be versus in civil, it's all about money, and you're kind of just ping-ponging money, and these are the reasons why. Look at these medical records. Look at this. So, you're using different facts, I think, but I would say the similarity, though, is that trial is always going to be the best negotiating tool. Criminal or civil, I mean, trial is the best negotiating tool. So when you come
and by that, I think what you mean, but just to clarify for the audience, is the other side has to know that you will try the case.
Absolutely.
If they don't believe you, no matter how much you pound your chest and scream and yell, if they know in their heart of hearts you're just full of it, then it doesn't work.
Exactly. And, every client, whether it's criminal or civil, I talk to them about trial, and I explain to my clients why I'm talking about trial. I always explain, I understand whether you want to go to trial or not, but we have to prepare for trial because we have to be ready for trial because we don't know what the other side is going to do, right? And so as long as we prepare for trial, if the other side want to go to trial, whether it's the government or, the civil defendant, great, we're ready. But most times they're going to see that you're ready for trial and you're serious about trial, and you're more likely to work that out in your client's best interest.
Right.
If I have a client that says, I'm going to trial no matter what, okay, we're going to trial no matter what,
Right.
but
Or how about when the
you
plea
get to
offer
door,
is effectively life? I mean,
right,
they force your hand,
right. And so whether civil or criminal, again, you walk through those doors Monday morning of trial, and the other side's coming with something, that really gives your client pause. Even that client was gung-ho about trial. It's like, well, the government was offering you 5 years of prison followed by 5 years of probation, special conditions, all the things under the sun. But now, day of trial, they'll give you a withhold court costs and call it a day, right? And on the civil side, they were offering $10,000. That's all they had for you. Now, morning of trial, we're at the $200,000 that we were trying to get in the first place.
Right.
So,
John, can you talk about limits a little bit? Because I think this is an interesting dynamic. Is not present in criminal. At the end of the day, in criminal, whether they offer you the maximum, jail sentence, or they're trying to do some combination or supervised release or community service hours, that's the creativity Keel was talking about. In civil, as you well know, it's basically just dollars and cents. Right. But whereas the government has a lot more discretion and flexibility, at the end of the day, sometimes policy limits. You're talking about open policy. Maybe you can explain the challenges of trying to settle a case in a civil context that might be worth $5 million to the client deservedly, and there's only a $25K policy.
So I mean, sadly that happens, right? And at least in the so the one public service announcement that I can make to anyone who's listening who may not be a lawyer is that at least for a motor vehicle crash, have uninsured motorist coverage, right? Because there is no legal requirement in Florida that you maintain bodily injury coverage, except if you cause a crash. It's backwards, right? You don't have to have it up front. You only have to have it if you caused a crash. Think about how that's backwards, logic up there in Tallahassee. But, that's the reality is they don't have to have insurance. People get in crashes, they don't have it, so you have this uninsured motorist coverage.
There's never a circumstance of criminal where I have to look at a client and say, sorry, the government ran out of freedom.
Right.
They can't give you what you're looking for. Yeah. In civil, I have to look at clients often, and usually it's from day one when we get the policy and tell them, look, it's going to take some creative maneuvering here to even afford you the potential of recovering more than this 10K or 20K or even 100K policy. And boy, that's not an easy conversation to have, right? Clients hire you, they're hurt, or God forbid, one of their loved ones has died or been catastrophically injured. They're looking for justice. Justice, as it relates to money, is a very big figure. And they're looking at you like, I don't understand why you're talking about $10,000 or $100,000. That's a drop in the bucket. That's a hard conversation to have. Now, there are hard conversations both ways, criminal and civil, for sure. There's a lot of commonality there. But I think civil, what's a unique challenge is you have to educate the clients, I think, a little bit more than you do in criminal. Everybody in criminal understands I'm accused of something serious. I know what my maximum exposure is. And they kind of inherently understand the nuance of what we can negotiate with. In civil, I don't find that. I find that some clients understandably come in a bit ignorant of the process and they've been wronged. I mean, John, how many clients have we had to turn down after investigations? I'm sorry, there's not even coverage, and that's a hard conversation to have.
It is, and it can obviously, you have the feelings of frustration and, well, who's going to pay for this? And like, I was wronged, and I'm like, that unfortunately, the reality is, as much as we want to be here to help people, if there's no one to get recovery from, if the person doesn't have a wealth of assets, and Florida does a good job, I don't want to say a good job, but they have very debtor-friendly laws and protect people's money, right? Come down here, retire, they don't want people to come after your money. So, a lot of times if there's not an available pot of insurance, lawyers, and ourselves included, sometimes won't take the case. Now, that's not always the case, but a lot of times it is, because essentially all the work we were doing is probably going to be all for naught, or for, to make that client at least whole on paper. But so, when you have that opportunity to say, look, they have a catastrophic injury, and it's like there's a $10,000 policy, and the insurance company tenders the limits, and like that's it. I mean, a lot of, and so you try to, and then you've got a $250,000 lien from the hospital, and so there is those different things. But the benefit we do have on the civil side is that when you give them that opportunity to pay to the insurance company, and they do not pay, and they should have done everything, they should have paid it, you can tell the client confidently, look, let's go to trial. This will give you an opportunity to get more money. We had a case we tried. It was a $10,000 policy. They offered $2,900 pre-suit. We're in litigation. The medical bills are over $20,000. They're offering $6,500 in suit after our client's deposed, and then we go to trial and get a verdict in excess of only $200,000, but they're going to be on the hook for everything, including attorney's fees, costs, and all that. So what could have been a $10,000 result may be upwards of $800,000, and the client, instead of getting $3,000 or $2,500, maybe after payment of medical bills, have $200,000. So it's a good and bad, but after those point in times, the only way to really get true value and true justice is to go to trial. And I think same with you guys when they're offering a non-existent plea. They're offering you, we'll give you 25 years. It's like, well, what's the point?
And, two things. The first is sometimes you're going to trial just to get something reasonable. But the second thing, something like a difference that just came to mind when you were talking is, there's, just to bring it full circle back into accountability, right? The government bringing a case that they absolutely should not bring, that the law does not support, they still bring it. They bring those cases. They try those cases. And whereas in,
what's the risk for them? Nothing.
There's no risk. There's none at all. I've had clients, we talk about how many trials we've had to verdict and then how many were dismissed mid-trial or on a judgment of acquittal, which is after the government has put on their case, right? Or, the first judgment of acquittal anyway. And it's like, I've been in trial almost 40 times, but only 25 or so are to verdict, right? Why? Because we're going to trial just to get that JOA. We're going to trial just to get this dismissal, right? We're going to trial so this, jury can give us this 5-minute not guilty. And then the government goes home and the same thing happens again and again and again to the people in our community. There is no accountability, nothing that, the government, they don't face anything. We don't have the resources to bring all of these cases, yet they're using resources to bring cases that really should be dismissed.
I used to joke, it's a perverse joke. I don't mean that it's like genuinely humorous, but it's the government's always playing with house money. They could shoot dice all day long and crap out every single roll, and it doesn't affect them one way or the other. Yeah, they're spending taxpayer money. That should be consideration. But brass tacks, at the end of the day, for the average line prosecutor that you're interacting with, outside of their ego, taking a loss doesn't feel good as a person, as a competitor. There's no real repercussions. Let me ask you this, Keela, because this is another difference. In civil, I've never had a judge say, I reject that settlement. You're going to trial. As far as I'm concerned, judges in civil are looking to clear their docket, and I understand why. There's a lot of lawsuits. Criminal, you can have a judge step in and say, I'm rejecting the plea between the parties, essentially. That doesn't happen all the time, but they can do that. I don't know. I mean, I'm assuming you had experience with that in criminal, and not having that here does feel like, at least for me, it gives us a little bit more control.
Yeah. Some judges do that. I find it, I don't know. I find it interesting that they do that, considering, the parties that know the most about the case being the prosecutors and the defense, came to this agreement, and some judges just, for whatever stated reason they have, say, well, I'm not accepting that offer. And the hardest thing about that is actually communicating that to the client. Because once you have this agreement, you're like, okay, well, the government agreed, we have this. And, you explain to the client now, the judge has to, agree to enter this plea, because at the end of the day, the judge is the one who is imposing the sentence. And I found it hasn't happened a lot to me, honestly. But I found that my clients really did not understand, once we had an agreement, why the judge would do that. And then it scares them for trial, because now they're saying, well, the judge is going to give me worse if we lose. So it throws sometimes an unnecessary wrench in the middle of it. And, it's not something I see in civil at all, really. I haven't seen it anyway, although I know that.
John, let me
the benefit
pitch
is,
it over.
Yeah, I was going to say the benefit is unless there's a a ward or a minor, judges don't have to approve anything.
Yeah.
This is our case. We have all total autonomy to control it as we see fit, and if the parties reach an agreement, it's settled. Mm-hmm. But if it's a minor, but even in that context, if you do the right things, you dot your T's, you got some kind of thing set up for them, the judges are going to sign off on it. I mean, some of them have 2,000 to 4,000 cases. Mm-hmm. So that's a benefit we have in civil for sure. Mm-hmm. So, but yeah, I mean, to be scared into trial, and then if I go to trial now, so then they sometimes will agree to a worse plea.
Yeah, and I have never seen or heard of a judge saying, well, that plea offer is just too harsh. I've never gotten that one,
Never.
Oh, no, that's too harsh.
And by the way, listeners, if you've ever had that, please let me know.
Yes,
I'll order that
please.
transcript and make wallpaper out of it.
Seriously.
John, can you do me a favor and educate people in the audience who might not have the hands-on experience? Keel and I, we did criminal before this. And when you're negotiating a plea in criminal, you're really just dealing with your colleague on the other side, the line prosecutor, to the extent that they want to defer to, maybe one of their supervisors. Mm-hmm. These are real people you can meet with, right? You can go to their office and sit down with. Conversely, on the civil side, we're always dealing with a man or woman behind the curtain, it seems like. Mm-hmm. You're talking to opposing counsel or defense counsel, rather, but they're really just the intermediary between the insurance company who's got an adjuster behind the scenes, sometimes out of state, and they're the ones holding the purse strings. So maybe you could talk about some of the frustrations or strategies in dealing with that interplay.
Yeah, I think, opposing counsel is not just, I think they're not just simply the go-between, and we saw this, Jordan, where you can have opposing counsel that believes in your case and that will actually kind of fight for you and say, look, you guys need to do the right thing here, right? We saw this in a case of ours, against a governmental entity that was like, not only that, they you need to pay the limits, and it's a little bit self-wasting. You need to pay it all, even the self-wasting part. We'll come up with it. So
no, let's give shout outs. I give shout out episode 1, Chris Stearns. He's a lawyer down in South Florida. Does defense work. He's a straight shooter. He cuts to the chase, and when the evidence supports it, it's not like he's just out there conceding anything. He's a tough fighter, super super sharp and aggressive, but when he reaches a point in a case where he realizes what's in his client's best interest is probably resolving for a fair number, he gets the job done. So shout out to people like him. I know he's not alone. Yeah.
And so you have that, you can have that relationship with the opposing counsel, but I think conversely, you could have opposing counsel that's like, we can win, don't pay.
Yeah.
Right. And they kind of get in the insurance provider's ear and they're like, don't pay. And, we're going to go to trial on a couple of cases that are like that. And so, you want to, I started.
Do you ever really know what the adjuster's thinking, right? That's what's different for me. It's like, if I talk to the line prosecutor, I can get a pretty good flavor of what he or she is thinking. So by the time I speak to their supervisor, to the extent that they were brought in, I already know what's been shared because I've been told it. Mm-hmm. I feel like, Keel, I don't know about you, but what I don't like on the civil side is I don't often have a direct line to the adjuster. Mm-hmm. There's often that go-between, and I don't like that game of telephone because it's like, I can send an email, I could send a letter, and I know they're going to read it, but sometimes I just want to pick up the phone and be like, let's meet in person and let me show you what's what, You're
waiting a lot in civil also. You can send that email or make that phone call, but they're going to take a while to get back to you with that number. And the other difference, and it's a little different with private practice, right? But you see those state attorneys in court in criminal, right? You see them every day. So I know where to find you is really the
There's no place to hide.
Sometimes I used to just go to court I need to talk to you, and if you're not answering a phone call or an email, I just know where to find you. So I'm going to go in court. I'm going to be patient, but I'm going to talk to you about my client, and see what we can do to get this resolved. And if it's not you, I'm just going to kind of talk about Miami. Then if it's not this line attorney, then it's their CT, their chief training, the chief in that courtroom. And if it's not that person, then it's the senior supervising attorney. You know who all those people are for each courtroom, for each place. And so you just know who to go to directly, and you have that open line of communication, like Jordan was saying. So it's definitely different.